Welcome to the second panel of today's conference. This panel is going to address trends and developments in UK collective actions. The observant amongst you might notice that we're currently one short. Ayse is hopefully going to be here very, very shortly and will join us as soon as she can. Firstly, by way of introduction, I am Neill Shrimpton, the head of the London litigation team of Brown Rudnick. What are my credentials for standing here and presenting on group actions, collective actions? Well, over the last 3 or 4 years, Brown Rudnick and I in particular have been very busy on quite a few group actions, with one of the funders sitting to my right whose identity will probably become clear in the course of the panel. In addition, we work very closely with Eleanor and her team when helping the funders in the room who are considering and documenting their own funding arrangements in respect of these types of claims. I can't promise you crazy beard competitions or monkeys that Stephen offered you earlier, but I hope that to the funders and the lawyers in the room, I think group actions are certainly highly relevant. It's an area in which most, if not all, funders have a great interest. So first of all, with that introduction, if I could just ask the panellists to introduce themselves, perhaps again starting at this end.
Thank you, Neil. My name is Stephen Friel. I'm the CEO at Woodsford. I'm a litigation lawyer by background.
I think this is working. If it's not working, I'll have to boom. Any help? Shall I just shout? There we go. I'm Susan Dunn. I'm one of the founders of Harbour Litigation Funding, and I realised the other day that it's 21 years that I have been in funding, so that made me feel very old all of a sudden. But I'm also a lawyer. I've practiced in the US and in the UK, and been funding for a very long time. Also the chair of the Association of Litigation Funders.
Good morning, my name's Robert Marven. I'm a barrister at 4 News Square. I've probably been doing costs and litigation funding also for about 20 years now. I remember the good old days when it was none of this would ever have happened. But the world has moved on, and I spend a lot of my time advising on, arguing about litigation funding, when litigation funders are liable, looking at packages of funding and ATE insurance and CFAs and what have you, and either just making sure they all work or getting them certified in the CAT or whatever. That's what I do. It keeps me busy, and it's a booming industry.
Ayse, just in the nick of time, would you like to introduce?
Yes, such an entrance. I didn't plan that. That was because of tube strikes and train strikes and lack of cabs. I'm Ayse Yazir. I'm the Global Head of Origination at Benchmark Advisors, and very pleased to be here.
Pleased to have you. So, just by way of overview, what are we going to talk about today? We're going to start with the Competition Appeal Tribunal and talk a little bit about the experience to date of litigating cases in that context, in particular, challenges for funders, particular concerns for funders in that context. We're then going to turn and look at some of the other structures, procedures that are available under English law for the prosecution of group collective claims, and then we're going to talk a little bit about the types of claims that we're seeing at the moment. So, Ayse, I was going to start with you, but I'll give you a moment to catch your breath, and perhaps we could start with Stephen instead. So, just in terms of the Competition Appeal Tribunal experience generally to date, and from the funder's perspective, what have we learned about the process? What are the challenges, and how, as a funder, do you look to overcome those?
Sure. So Woodsford's one of the most active funders in the CAT space. We have a number of pre- and post-CTO cases, and we have more in our pipeline coming through. And so it's from that context that I talk about the CAT. And the experience thus far is good. Neil, you asked about the challenges, which there are undoubtedly some challenges, and there have been teething difficulties. But there's no doubt that those challenges are vastly outweighed by the opportunities that the CAT regime affords. Opportunities for consumers to get collective redress, opportunities for lawyers to do cutting-edge cases, and ultimately opportunities for litigation funders like Woodsford to develop our ESG and access to justice business and to generate significant potential returns for our investors. I see the cat as a good, positive thing. In terms of our experiences, it's a fledgling regime and there have been difficulties. The cases have taken longer than we would have liked to get to the state that they have, but they are now moving into a second generation of maturity. And I think those funders and investors and lawyers and others that have been through those early years will now start to reap the rewards. We've been to the Court of Appeal and the Supreme Court more often than in other practice areas, but that comes with the benefit that we're shaking out the issues. And actually what we see from the judiciary, having gone through these layers, the CAT at first instance, the Court of Appeal and the Supreme Court in particular on Merrick's and MasterCard, is a real positive reaction from our judiciary to the CAT regime and in particular to the role of litigation funders in that regime. With minor and limited exception, every CPO application that has come to final resolution has been found in favour of the claimants, and all of the, or most of the substantive legal and procedural issues that have been decided in a pro-claimant way. And we see the reaction of the judges to litigation funding. There is a universal acknowledgement among the judiciary, from first instance through to the Supreme Court, of the critical nature of litigation funding for the CAT regime. This regime would not exist if it were not for litigation funders. The class does not have funding if it is not for litigation funding. The access to justice that we bring is recognised time after time by the judiciary. And so whatever challenges there might be, the context is one that is entirely supportive and embracive for litigation funding. So a quick few remarks about our cases. I'll take you a quick jot through them and point out some of the interesting features. First, the trains case. We are funding the class representative Justin Gutman in a claim he's bringing against train operators on train lines in and out of London. We've brought the claims in two waves. The first wave against the operators of the Southeastern and Southwestern franchise, and after being successful in the CPO on that, we brought a second wave against other train operators. The first claims were commenced in 2019, so at 4 years in, it is taken longer than we would have liked, but we've gone to the Court of Appeal. We've got our CPO, we're still standing, we've survived, and indeed I would say the claims have thrived because of the positive statements by the court. Two particular issues I'd point out. One is that in most areas of commercial litigation funding, the role of the litigation funder isn't an issue in the litigation. The litigation funding agreement, the nature of the identity of the litigation funder is irrelevant to the claim. But the defendants in the CAT cases have sought to make litigation funding an issue. They have sought to raise arguments that the class representatives should not be certified because their funding isn't sufficient, that their litigation funding agreements are somehow defective, that their adverse costs provisions are not satisfactory. And they've tried this in all of the cases. They've been largely unsuccessful. The CAT has, and the other courts have robustly defended the position of the litigation funders. And one of the things we've seen from the cases that we have been doing is that the small number of the long-standing credible litigation funders, the founders of ALF, the founders of ILFA, who have strong balance sheets, who have transparent financial and corporate governance like Woodsford and Harbour and others, the CAT appreciates us, is prepared to stand up for these litigation funders and say, no, if these funders are involved, we're not going to have much truck with these attacks on litigation funding, and that's a positive sign for us. The second thing I'd point out about the trains case relates to the fact that in many ways the CAT regime is the only opt-out regime that we have, and in order to get into the CAT regime, it has to be a competition claim. One of the arguments that we faced in our trains case was that this is really a consumer protection case, and that the claimants were trying to dress it up as a competition claim in order to shoehorn it into the CAT regime. And I'm glad to say that the CAT and the Court of Appeal had little truck with that and found in favour of the claimants. And what we see, therefore, is the CAT willing to have an expansive definition of what is a competition claim and therefore what can be covered by the CAT regime. We're also funding the RoRo claim, which is a claim, it's a follow-on claim, following on from a European Commission decision in a cartel claim. And a couple of interesting points from that. The first is that it is a cartel follow-on claim, so liability in large part has been established. And further, there is a number of defendants, multiple defendants, each with deep pockets and with joint and several liability, and that's a good position for claimants to be in, to have multiple pockets jointly and severally liable for the same claim. And then finally, on the claims that we are in the open, we've got the Sony claim, which is a recently filed claim, not yet got the CPO, but I hope to be sitting here next year talking either about the success in the CPO and or the settlement of that case.
Thank you. Ayse, would you like to comment from your perspective?
I agree with Stephen. It is, I think, like Susan, I like one of your comments. You said if it wasn't for us, CAT would be empty. So when you look at CAT, when it was from 2015 to 2021, there were 0 cases. At around 2021, there were 4 cases that got the green light. 2022 is 9 cases. So it's getting really busy. We are keeping CAT very busy, and we are, like you said, Stephen, several times, we are providing access to justice. And when we think about, I think, let's put the scene up first, Neill. When we talk about group actions, everyone asks me, Ayse, you are a litigation funder, what makes you very busy? Like, it's that arbitration cases or litigation cases. It's definitely group actions. As litigation funders, we love group actions. Why? Because there are large claims. That means that there's large returns for us. Most of these cases are follow-on cases, which means that there's already causation. You need to work on quantum and damages. And you involve on the start of the case, which I find it very exciting, and lots of litigation funders also find it very exciting as well. We briefly mentioned CAT, and I will mention also the cases that we have in CAT as well. And also there are huge changes happening in CPR 19.6. When Lloyds and Google decision was given, especially discussing this similar interest, it was a big shock in the market and thinking about how we are going to deal with damages. But we are also going to discuss shortly, Commission recovery decision has also opened the door a bit on 19.6, which they explain the similar interest and actually brought a bit more clarity on damages. When you think about GLOs, well, there is one GLO is already gone, Volkswagen, that has been successful for 90,000 clients, over 100 million damages. And now there are 11 GLOs are due to go. And this is a quite substantial number. Lots of new players are coming to the market. When I first started Neill, when I was doing the product liability cases, one of the first ones was the HIPS cases. And we had 330 clients, and I thought I conquered the world. And this was 2018. Now we are talking about millions. We are talking about big American law firms walking into this market, like Keller Lagners, Milbergs, PGs, and many more. And securities actions, the other group actions. That's why we are very busy, and that's why group actions are very important for us. When we talk about really big cases, I think 2 really big cases that's going through CAT are our matters. One of them is FX case, and the other one is Merix, MasterCard and Visa, which we are doing commercial and interchange claims. Both of them are very important. And why? Let's start with FX, because it was the first carriage dispute that went to CAT. And it's a really big, I think you all know the background of FX case. It was against 5 banks on playing with the FX. But when it went to court, and there was a carriage fight, the judge said, none of you are going to get the carriage. Of course, that was kind of disappointed for the parties. But also, we learned quite a lot as well. So what were the concerns when it came to court, and why didn't anyone get the carriage? One of them was the causation. The court said you need to prove your causation stronger. So they thought there should be more work has to be done. And also, this is a follow-on claim, and we tried to bring it as opt-out. But the court said, no, looking at the sophistication of people, which are commercial clients, they should be considered as maybe opt-in, and also you need to get their approvals. That's very different than what Merix is going through. I think the judge took a different view there. But even though they are commercial, let's assume a business who has 20 million return, and you go to this business and say, you have £15,000 claim, do you want to sign up, and let's book build. They will not going to be interested on that. I will be very interested if I have a Volkswagen to get £5,000, but these commercial businesses will not going to be interested because there will be some cost implications, there might be adverse costs, they have to prepare witness statements, and they don't want to face that. So that was the other discussion, and the court said, maybe you can consider this as an opt-in, but I don't think this can be opt-out. If you can appeal that or bring it as an opt-in action. So we decide to appeal the decision. So these were the main things, and there were no carriage, like I said. And when it comes to court of appeal, I am putting my, because I do quite a few range of cases, not just class actions. In arbitration, when you look at a case, and if the main problem is jurisdiction, you usually go for bifurcation and deal with that, then go to merits section. I think here, one of the problems was, when there was a carriage fight, instead of the court dealing with that as a primary issue, they decided to deal with all of the issues, and which will include the carriage fight. I think it will be easier for CAT, of course this is my personal view, but they can have their own view, it might be different. It will be better to have that carriage fight earlier, so whoever doesn't get any certification can stop the action, and that will kind of ease down the weight on court's back. And very briefly, I will move to Merix as well, and you probably all know Merix case is going around for a long time, interchange claims between 1996 to 2008. They had 45 million clients. Now we are covering commercial companies, which is we have 4 portfolio deals for opt-in and opt-out, and also we are bringing debit claims as well, which means that it was very limited to certain type of merchants. Now we spread that to all of the merchants and consumers. So I think that's a very good. In Merix, actually, we are having positive response. Judge himself said it is an access to justice. We already have positive Sainsbury's decision. And 6th of April, we are due to have our CPO. And as far as I know, all the law firms are working collaboratively.
Thank you. Robert, if I could come to you next, maybe. Stephen mentioned a little while ago, 100% record on certification. I think there's a recent example in Gormson and Meta of certification being refused.
Yes.
Stephen caveated it by finally determined. Do you see that one as potentially might go the other way once finally determined? And if not, what funders learn from it?
What the CAT has said is that they're not going to certify it at this stage. They've essentially given the applicants 6 months to go away and come back with what they have made very clear has to be a radically different proposal. And I'll come to what the CAT said the problems with the proposal were in just a minute. They have said, I think in so many words, if you're just going to tinker at the margins, you might as well take this to the Court of Appeal now, because there's no way if you just tinker. We're going to certify this for a CAT collective action at all. Now, the underlying detail isn't terribly important, but the key thing to what the CAT said was this. This is a new jurisdiction, and as claimants in this jurisdiction, you have certain advantages, especially in an opt-out procedure that essentially, and this is the way the world is now, you have millions of people perhaps with the same grievance. Most of them, if it's an opt-in procedure, just won't bother to sign up, however easy you make it. So in the CAT, you have this opt-out procedure that everyone's in unless they actively opt out. That is tremendously important for reasons my colleagues have explained. That firstly, it gets decided holistically, but it also works because you need that procedure to provide the funding, because the way the funding gets paid for is that the damages are awarded for the whole class. In reality, not every member of the class will claim, so there will be a remainder of damages, and that can pay for the funding for the litigation. And that is why, in terms of bringing the defendants to justice, in terms of making it work financially, that the opt-out procedure is so important, and why we'll discuss what the courts are doing, but at least on the face of the statutory powers, the CAT is unique, but it is only for competition claims. But in this case, the CAT refused to certify, applying what was called the process test. Again, this comes from Canadian jurisdiction. What it basically means is, in its expansive definition, and the CAT was very clear and said repeatedly, this is not to do with the merits, but if you want the perks of a certification, you want to be an opt-in, an opt-out claim, you have to satisfy us at this stage and not later that you have a roadmap, that you have a plan. You don't have to persuade us you're going to win, but we need to know if these allegations are going to be fought, how are you going to go about proving your case? What directions do you want? How do you see the issues? And it's fair to say that the CAT eviscerated the expert evidence and the legal arguments and said this is a very complicated area. It's what's called a two-pronged market. So Meta isn't just marketing social media, it's marketing advertising. How are you going to show that there are unfair practices here? How are you going to show the loss to the claimants? We don't need to know you're going to win, but we need to know how you're going to do that, what directions you're going to be asking for, and that just isn't clear, and for that reason we won't certify. But as I say, they didn't kill it off straight away. They said, we'll give you 6 months to come back with something that has to be radically different. I mean, I think what this shows is that on the facts, the CAT isn't always going to certify. But I mean, it's probably helpful that the CAT has set out in this judgment what they expect. As I say, they haven't shut the door altogether, but they have said you have got to show us how you're going to make it work. And by the way, they've said, you know, this is really what we should be doing in case management in any litigation, but because there are bonuses to the CAT collective scheme, there is a particular stage at which you have to do this, not just generally in case management as the litigation proceeds. So maybe a setback for the actors in that case, but I think not something that makes me worry that the CAT jurisdiction is generally going to be ineffective. I mean, I think the message is, especially if you've got a very complicated claim and a very hard-fighting opponent, you have got to be able to persuade the CAT at that certification stage how you're going to run the claim, what's your roadmap, what are the points you're going to argue, what are the conclusions you're going to want to make them reach, and where are you going to be putting your evidence in.
Thank you. Susan, Robert mentioned their payments coming out of the leftover damages. As I'm sure everybody in the room is aware, we're awaiting the decision from the Supreme Court in the trucks litigation. Would you like to say something about that?
Yes, and I mean, just on that point, it's a weird anomaly of the CAT to have that, which could do with some clarification, although those are familiar with the statistics of what the collection levels or the distribution levels are in the CAT are, they typically run at under 20%. So I think whilst that remains the case, that's kind of okay. But in a world where we get more and more able to figure out how to distribute funds much more efficiently, that probably won't be okay. The Supreme Court cases, and this just highlights the points that Stephen was making, which is defendants who know they're really on a sticky wicket because it's a follow-on action or there's just clear wrongdoing, are trying everything in the book to try and delay, to try and get things knocked out. And, you know, we definitely see, as a funder, we see people coming to us with cases saying, this is a case that's going to go in the CAT, it's an opt-out case, and you go, but there's no competition element to it. And they want it simply because they want the opt-out, because it's the only way that many, many cases are, frankly, economically viable. If you look at the cost of sign-up per claimant, if you can't get into the CAT or under 19.6, they're not viable. And so it's in the interests of these defendants to find everything they can, and why has Merrick's taken so long? And, you know, we talk about the CAT being a nascent jurisdiction. It's going to be 20 in May, 20. That's a long time that it's taken to get this going, and it just shows you how difficult it is in these circumstances to do so. The latest game being played by one of the defendants in the trucks matter is to try to, because the weird anomaly about the CAT is that funding is permitted, but it's the only jurisdiction in this jurisdiction, it's the only forum, in this jurisdiction in which damages-based agreements are not permitted. People try and remember why it was that they thought that. I think that they somehow feared that there would be a compensation culture piece that came from allowing DBAs, which I think is underestimating the low adoption of DBAs. So, cunning wheeze that the defendants came up with was, if we can make litigation funding agreements somehow seen to be invalid, then we can defeat all the funding in the CAT, because as we've all described, the CAT would have tumbleweed going down its central aisles if funding were not available for the cases that are in the CAT. So what they have tried to suggest is that litigation funding agreements should be deemed damages-based agreements, because guess what? If that succeeds, it gets them kicked out. Now, if you go back into the costs history, which I'm a bit of an anorak about, and go back all the way to dates predating the Jackson Review of Costs and all the acts that came with it, not once did anybody contemplate that litigation funding agreements, which after all are funding by a third party, they are not the agreement, that we are not running the litigation. And the whole point about DBA regulations is the protections for the claimants that are being funded by the very people who stand to benefit from it. Whereas, as we all know, we are removed from that, and all we do is pay the bills and hope that the case works out successfully. But if you could suggest that litigation funding agreements are deemed to be DBAs, then of course none of them are compliant, because none of us ever contemplated that they are DBAs, because we're not the representatives. They have lost that argument in first instance. They lost in the Court of Appeal, in both cases extremely well-reasoned, one could say blindingly obvious, bases for doing so. But they did get leave after a long wait to the Supreme Court. And we should expect that that reasoning is extended. But, you know, it is one of those things that's being used as a device to try to kick out the funding. Because if you win, it's worth giving it a go. Even if your percentage chance of success is tiny, if you succeed, the impact is that you cause agreements and things to be looked at, but it's a good wheeze, and it's one of the many technical arguments that we see defendants who really have no defence seeking to make use of, because they're trying any way they can to sort of point over here rather than, oh dear, look, we've got no defence to this wrongdoing.
Thank you. We've spoken so far only about the CAT, and as Stephen said, it's a relatively narrow jurisdiction, even if there's an element of shoehorning sometimes to get cases on the fringes in. There's obviously a variety of other ways in which collective actions can be brought in this jurisdiction. One of them that's been mentioned a couple of times already today is the representative action under CPR 19.6. Robert, if I could perhaps start with you on this, just to explain what that is and the recent decision in Commission Recovery. Which is also
what it is and why the developments are potentially important, if rather piecemeal. As we've heard, CAT, but only competition claims, you have opt-out. That doesn't exist subject to what I'm about to say about 19.6 in court. We all know there is group litigation. That is emphatically opt-in, and the funding and the lawyers, apart from inter-parties recovery, have to be paid for by deductions from the damages of those claimants who have opted in. So you have this other jurisdiction of a representative action. And in fact, the concept has been around since the 19th century, and before it was ever codified in the rules of court, that in certain circumstances, a member of a class who has the same interest as others can bring a proceedings on as a representative. It's called a representative action. And this has applied to shareholders in companies when company law was very different. It could be an argument about a village green where not all the villages are going to be. It could be anything like that. But the world has moved on, and you're now looking at things like, for example, suing Google or something like that, where it's vast. It's not a competition case, so it's not going to be in the CAT. Can you use this procedure? Well, a Supreme Court decision says, yes, you can, but left wide open the question of whether it was practicable. That they were all with the argument that this is a flexible jurisdiction, it should be applied and adapted to the modern world. But at the end, they left the specifics to the lower courts, but at the end of it they said, it's far from obvious to us, however, that a representative can recover damages on behalf of the class, or indeed that the class, that if, even if he could, that people who are not represented and haven't signed up to a funding agreement can be required to make a contribution. Now, there's a more recent case of Mr. Justice Robin Knowles called Marks and Clark, where this came back to him, and he said, well, this is suitable. The damages actually here will be the same because it's a commission case. And he said, I don't have to decide this now, but my immediate reaction is I can't see any obvious reason why damages on behalf of the class can't either be paid into court or held by a trustee. And if that stands up, that will be a significant development in this jurisdiction that will help to make it work. A question, I'm sorry for the funders in the room, it seems to me to still remain unanswered by the judiciary, is if your funding agreement is only with the representative, can you take a deduction from damages as a payment for your funding from the awards to those who have not entered into funding agreements with you? And I think that is a question that the judiciary has yet to develop. My own view on this is that these developments by the judges, this application of 1960 to the modern world, are all extremely welcome. But really what we would want to see is exactly what you have in the CAT, which is legislation, because necessarily with no discussion with the judges, if it's being done by them, it's going to be slightly piecemeal, it's inevitably going to be piecemeal and potentially haphazard. And I think there will come a point where judges are likely to say, no, actually this may be a good thing, but this isn't something we can do on the hoof. This needs Parliament to intervene. And so I think something in the courts equivalent to what we have in the CAT in the modern world is called for and would be welcome. One other anorak point on this latest decision that I mentioned. We've long thought that you can't assign bare causes of action. If I have a claim, I can't just sell it to someone who has nothing to do with the claim. There have always been exceptions where there's been a connection between the assignee and the claim of what's called a pre-existing interest. It's not a problem in the CAT because you can have a representative. But in court, the claimant actually has to have the claim. Now here, the claimant was a vehicle. But the judge said, well, this doesn't offend the law against the assignment of bare causes of action, because the claim here is not just any old claim, it's a claim for a secret commission, and that secret commission is property, and therefore the cause of action is being assigned along with the property. I have to say I think that's quite a stretch. A cause of action is in itself property, and I think that whether or not the rule needs attenuation, the identification that if the claim is for property, then you can basically assign the cause of action because you're assigning it for property is something that is open to further consideration. But that's just my anorak point. On the broad point of 1906, I think it is welcome that there are these developments, but I think sooner or later it will be much better if Parliament intervenes and does it holistically.
Thank you. Stephen, coming to you, would you like to just talk a little bit about how Rule 19.6 is now starting to be used in practice?
That's right. So Woodsford's a leader in the securities litigation space. The majority of the Section 90A claims that are in London right now have been originated, funded, organised, or all of those by Woodsford, and it's a space we know very well. And our journey in putting together these Section 90A securities claims and the journey towards CPR 19.6 has been very interesting. So we start from these claims 4 or 5 years ago, and we look at the fact that there are not class action mechanisms for bringing these claims. And so we scratch our head and we say, well, the claimants can't be brought together by a class. How can they be brought together? And the obvious answer to that is by contract. So we had to work out a way of getting out there, identifying the investors, the claimants, the shareholders, and bringing them into a contractual relationship with each other. And that's what creates the group. And so in our early cases, that's what we did. We enter into a large number of agreements with a large number of shareholders. And those shareholders have to enter into a large number of multiple agreements. They have to enter into a litigation funding agreement with their funder, a retainer agreement with their law firm. They have to be covered by an insurance policy, and they probably need to have some constitution for making a decision among themselves. So in a claim where there might be hundreds of claimants, you can see that there are thousands of contracts. And so that's where we started. That was inefficient and laborious, but we did it. And one of the great advantages of doing it was that we were able to develop our business of doing it more efficiently. And so we were able to realize that by being efficient at doing this and bringing these people together, that in itself generates value. The next generation of our business then was to say, okay, well, we've got all these contracts. Let's now make the contractual structure more efficient. And we've succeeded in doing that. We've greatly streamlined the size and number of contracts that the parties need to enter into, but it's still a contractual structure, and we've worked well on that. So we're now moving into the next phase, and this is where 19.6 becomes relevant. Having created a very efficient book building service, having created this way in which we can bring all the claimants together, we've got efficiency in the book building, we're now looking at efficiency of the litigation process, and that there's still a lot of inefficiency in having to have lots of claimants on a claim form, lots of claimants as active participants in the claim, and with no real method of bifurcating. And that's where CPR 19.6 comes in very readily. When most people read the Lloyd and Google decision in the Supreme Court, there was a, oh, well, that's it. This is a bad decision for collective redress. But actually, I think Lord Leggett in particular was trying to bring us towards a very efficient way of using CPR 19.6. He said this is actually a very suitable way of bringing claimants together. And actually, this is a very suitable way of bifurcating claims so that you deal with the defendant's liability first, and only if the defendant's liability is established do you need to get to the second phase of working out how the individual damages position of the claimants need to be addressed. And the experience of most litigators is a defendant faced with having their liability established first will either settle before that day of reckoning, because ultimately a lot of wrongdoing is at the root of these claims, and so you won't ever get to the stage of having their liability established. Or their liability will be established, and yes, you then have to move into individual quantifying. But having their liability established then leads to a very likely settlement. And so we started looking at this. How do we use CPR 19.6 in an efficient way? Because we're in the shareholder space, and because we have a relatively big but self-defined group of claimants, we have decided that we can still say opt-in, that the claimants will still need to be in a contractual structure, but it is an opt-in approach to CPR 19.6. The claimants will have opted in, they will have come together, but then one of them will be the representative, and so we will bring efficiency to the litigation. There will be only one claimant in the litigation. We will seek that the claimant will then bring a claim for a declaration on liability. There will be a streamlined litigation process, and only if there is a liability finding will then all of the claimants who are in a contractual structure with each other, and therefore the funder has a certainty of where its return is coming from, will we have to get into individual issues. So we've got our first of these claims going through. The first of the defendants faced with one of these claims has sought to strike it out on the basis that this is not a proper use of CPR 19.6. I think they're wrong, and I think the court will soon establish that we're wrong, and then we'll have this very good hybrid model of using 19.6 on an opt-in basis. But that then leaves open the situation, that's 19.6 on an opt-in basis. That's still inefficient, particularly beyond the security space. And even within the security space, it's inefficient for retail consumer shareholders as opposed to institutions. How do we crack the nut there? And I think Robert is absolutely right to identify that the case that he discussed has given us an indication from the judiciary that whilst there isn't a statutory formal basis for a funder to take its return from an opt-out class outside the CAT space, that there is a willingness on the judiciary to create that, and if the judiciary don't create it, then the legislature should. I'll finish this particular point on an anecdote. A couple of years ago, I went to a very strange birthday party for the 21st birthday party of the English Civil Procedure Rules, and there was present at this event a large number of the judiciary. There was the Master of the Rolls and two former Master of the Rolls. There were a number of Court of Appeal and High Court judges, and there were one or two Supreme Court judges, as well as policymakers and academics. And a dominant theme of this discussion of the Civil Procedure Rules was that when the Wolf reforms of the late 90s were being discussed, then there was a discussion that we're about to bring collective redress, proper, effective collective redress mechanisms to the UK. And 21 years later, there was a sense of disappointment in that room that we have not made good on the promise of collective redress, that we still have the defendants taking us to the Supreme Court on something as ludicrous as should litigation funding agreements be considered similar to lawyer contingency fee agreements and therefore thereby struck out. There was a palpable sense of disappointment from the judiciary on that, and therefore I sense a palpable desire to resolve these issues either through case law or, if necessary, by statute in a pro-claimant, pro-litigation funding way.
Thank you. Ayse, I just want to come quickly to you, just to talk about another mechanism under English law, the GLO.
Yeah. Thank you so much. When we talk about GLOs, Stephen said you are the securities kings, then we are the GLO queens. So we are doing quite a lot of GLO matters that's going through the court at the moment. There are two different types. When we talk about Volkswagen bond cases, let's talk about emissions. That is taking quite a lot of attention, and also last year there was a really good outcome on Volkswagen bond claim. And what happened with Volkswagen one was there was a cheat device, and it was very obvious. Volkswagen has already been subject to fines in US. They pay compensation. They came to UK and they said, well, actually that's a different law, so it doesn't count. But what happened is, again, because they already accepted liability, it was a very specific cheat device. The case has been settled. But of course, lots of things were learned during Volkswagen One action, because there were lots of different law firms involved, and there were lots of disputes. Law firms kind of learned how to work together. Now we are looking into Volkswagen 2 claims, which is actually a bigger claim, which includes the Porsche motors, the Mercedeses, and quite a variety of cars. Why much more larger group than what Volkswagen One was. So it is it's a bit complicated on a way that it is a smarter cheat device, and when it goes to a court, probably the expert evidence will be necessary to prove these devices were faulty. And because Volkswagen has already taken their lesson from the first action, they only pulled a few of the cars off the market, and the others are still going through. But the thing is now, because there are quite a few actions coming through, these are BMW cases, Skoda, Audi, Jaguar, there will be around 11 GLO applications this year to the court. 11 GLO applications. This is very close to 2 million people who will bring claim. Probably when the GLO application has started, it will be more. Mercedes has already happened, and we are now waiting decision on that. And how the court's going to deal with all these claims that coming in front of them? Are they going to take just one of them as an example and work on them and ask the others to stay? Or they will take 2 or 3 examples? So that's not very clear. But these cases are very interesting for us. Also, we actively involved in book building. And actually, it was really good to see how law firms, like one of the law firms that we usually work on these matters is Litigation, that we create this structure and they find it very profitable. It also involved thinking about how budget will work, how after the event insurance will work. And those were actually the discussions that came to FX as well. As a litigation funder, you shouldn't just think about the legal merits of the case. What you create as a structure is very important, because that will be a threshold to everyone else. And that's what we have created. And we are waiting the outcome of Mercedes and see what's going to happen with the upcoming GLOs.
Thank you. I'm conscious that we're rapidly running out of time. I should allow a little bit of time for questions. So does anybody have any questions that they would like to ask? There's one down here.
Yes, my name is Per from Cologne, Germany. My understanding of EBAs is that multiples as a share are not affected. Would that be a way out of the situation we have right now?
Look, I think that with this case, of course, what it leads to is people then speculating, not always terribly helpfully, about what possible outcomes might be. I think that it's a matter for each funder to look at things and look at how they do things. Some funders do entirely multiples anyway. And so I think it's not desperately helpful to speculate on what possible alternatives there are, etc. But yes, I mean, look, the DBA regulations talk about percentages, so they apply to where you're charging up to 50%. And I think that's actually just always an interesting point on DBAs, that people sort of say, oh, how much is the funder charging? Let's not forget the DBA enables lawyers to charge up to 50% of the proceeds. But look, I think it's not super helpful to say, oh, well, could you do this or could you do that? I think each funder has to take their own advice from people like Robert to say, to see what they think they might do in general terms, sort of regardless of this case, because one of the things we know, and I was chatting about this with somebody earlier, is percentages aren't always brilliant, because 30% is not a very large number, which is, I know nobody cries tears for us, but most outcomes are disappointing. So a percentage rather than a multiple is not always the best place to be.
We've probably got time for one more quick question, if there is one. But if there isn't, we are now due to go on a coffee break, so hopefully the panellists will stay around for that. So if you have any questions you want to ask on a one-to-one basis, hopefully there'll be an opportunity to do so. So it's a half-an-hour coffee break. Please come back at about 12 o'clock. And in the meantime, thank you very much to the panellists.